Perfect. Okay, let's get started. Hello, everyone. My name is Carly Wilson. I'm a lawyer with Iler Campbell. My pronouns are she and her. I wanted to get things kicked off today by doing just a quick land acknowledgement, something that seems a little bit more important to me personally now that I've been locked down in the same place for 6 months. As many of us are settlers on this land, we pay respect to and recognize that this is the land of the Ojibwe, the Anishinaabe, and in particular, the Mississaugas of the Credit First Nation. That's whose territory I am on in my office/bedroom today. And this territory is covered by the Upper Canada Treaties. This recognition of the history, contributions, and importance of Indigenous peoples must be connected to our collective commitment to make the promises and the challenges of the Truth and Reconciliation Commission real in our communities. And today in our community, we're going to be talking about how to navigate post-pandemic changes at the Landlord and Tenant Board, or the LTB, as we're going to be calling it today, because I like that familiarity. So let's get started. First things first, we're coming to the end of our free webinar series, but there is still time to sign up to see my colleague Efile next week. She's going to be discussing tips and considerations for employers as employees return to work. Also, keep in mind that all of our presentations have been recorded and are available. So if you see anything on this list that catches your eye, I encourage you to check it out on our website, which is ilercampbell.com. So here's a brief overview of what we're going to cover today. We're going to start with what the heck happened at the Landlord and Tenant Board since March, and discuss a little bit about the very contentious Bill 184, which dealt with landlords and tenants. And then we'll get into what to expect when you're dealing with the LTB today, or as I'm calling it, what to expect when you're evicting. And then we're also going to look a bit about what may have changed and ways that you can change your actions to try and streamline any applications that are going through the LTB. And then lastly, we're going to do some questions. So if you have any questions, there's a question and answer space that you can put them into, and I'll be checking that at the end just to address everything at that point. So I'm probably not going to check it as we go through in case I answer your question later on. With that said, let's get going. First things first, this is legal information, which means that it is not legal advice. So what does that mean? It means that we're talking in generalizations today about how the legal process works and what to expect when you're interacting with it. I'm not advising you on how to proceed in any particular file. We'll have time for questions at the end, and I can help you with possibly more specifics about how the LTB works or the law surrounding an issue, but I cannot provide you with advice about specific tenants that you may be dealing with. So please do keep that in mind when you're thinking about questions. I'll also keep it in mind if there's something that I can't answer. Let's get right into it. So what has happened with the Landlord and Tenant Board since March? On March 12th, I was sitting in my office preparing for one of the bigger LTB hearings during my articling term at Iler Campbell. It was scheduled for March 20th. Our firm had discussed earlier that day what our plan was if things were going to be shut down. I called the LTB to check in and see what their plan was, since my hearing was in 1 week and things had been changing so quickly. And they assured me that they had been wiping down all of the chairs in the hearing rooms with sanitizer and that nothing was going to change. The hearing would go as scheduled. I called them again on March 16th just to check in. I was still in my office, but I was one of, I think, 3 or 4 people that had come in that day. This time on the phone, they said they would be sending an update about how they would proceed with the hearings very shortly. I received an email from the LTB at 4 o'clock that afternoon informing me that my hearing was now over the phone. I left the office that day to work from home for a few weeks. I have now gone into the office exactly twice in 6 months, and I have gotten very comfortable conducting hearings in my pajamas. What I'm trying to say is the shutdown at the Landlord and Tenant Board was abrupt, and like many organizations and services, they did not have a plan in place. In early April, they instituted the urgent hearing applications. This allowed applications that involved serious or pressing health and safety concerns to be heard on an urgent basis. While some of our clients benefited from this solution, the definition of urgent was messy, to say the least. Applications were reviewed pretty unevenly, and some concerns were definitely given more value than others. So while this was a valiant effort, I don't know if it entirely succeeded. The LTB was also plagued by some technical issues, likely resulting from large amounts of applications and also understaffing. So while the province had suspended eviction orders and enforcement, the LTB was still accepting applications. There was a period of time, I know, when the fax machine at one of the LTB offices only accepted faxes for a certain number of hours per day, but didn't communicate this at any point. So applications frequently had to be resubmitted. Following up is always really important with the LTB. We'll talk about that a little bit later. I also received a call in, I believe, early May from a rather panicked Landlord and Tenant Board employee asking if I could check the firm Visa card statement and confirm whether an application payment had gone through, because they had lost all record of payments for one full day. That was later sorted out, but that I think gives you a bit of an idea about what the LTB themselves were dealing with. Ultimately, they were working from home with limited staff in a building that's complicated. We all experience that at this point. Like, our workplaces have been shaken up, and the LTB was no exception. They're staffed by humans, and humans make mistakes. They were short-staffed and experiencing the same issues with reduced support that the rest of us were. And they were also waiting for direction from the government about how on earth they were going to proceed. So that's kind of the situation as we left it at the beginning and throughout the pandemic. And then I feel like now that everything was absolutely topsy-turvy and everyone was confused, the government decided to throw some new legislation into the mix, and that was Bill 184. So the province introduced Bill 184 on March 12th, which I think was some pretty bizarre timing, and they continued with the process for its passage throughout the pandemic. The bill eventually came into law in July of 2020. The bill itself has an intimidating nickname that some of you might have heard. People called it the eviction bill. There was significant outcry about how streamlining the eviction process could possibly be considered a priority during a global pandemic and a national housing crisis. The law ended up with the official title of Protecting Tenants and Strengthening Community Housing Act, which frankly is a misnomer. The bill undoubtedly improves procedures for housing providers and often does so to the detriment of tenants. In the future, I think it would be helpful if the government just called a spade and described legislation accurately, but that is just my opinion. That said, are there any positive outcomes that we can take from Bill 184? And I think there are a few changes that definitely benefit housing providers and that I would like to highlight. So the first one is the ability to have payment agreements. So the bill added a new section to the Residential Tenancies Act, which allows landlords and tenants to enter into a repayment agreement for arrears before attending a hearing at the Landlord and Tenant Board. And that repayment agreement can include eviction as a consequence if it's breached. So these agreements would need to be submitted to the Landlord and Tenant Board for approval, but essentially instead of having to go to the Landlord and Tenant Board to get a mediated agreement that's then enforceable, tenants and landlords can figure them out away from the Landlord and Tenant Board and then submit them. They need to be reasonable, but for some arrears applications, this is a really helpful solution, and it could also lighten the load a bit for the LTB. Bill 184 also allows for post-tenancy applications. So what this means is that landlords can now pursue previous tenants for arrears or damage payments for up to 12 months after their tenancy has ended, and they can pursue those repayments at the Landlord and Tenant Board. So previously, pursuing tenants used to only be available through small claims court, which I'm sure a lot of you know is a very slow and expensive process, and that led to most housing providers kind of cutting their losses and absorbing their arrears. And this offers a different solution, although I do worry that it will add even more weight to the shoulders of the Landlord and Tenant Board. But those are two positive outcomes that we can see coming for housing providers from Bill 184. So now that we know kind of where we're sitting, things were a big mess. Bill 184 came in. What can you expect when you're evicting at the LTB? It's not good. I don't have good news for you. I was saying just before the presentation started that there's a lot of people here today, and that's really exciting, and I really wish that I could share some positive information, but unfortunately that's not the case. So the first thing that we're dealing with is extreme delays. The LTB was backed up before the pandemic due to budget cuts and staff shortages. Since the pandemic, the delays are astronomical, and there still does not seem to be a plan in place. So technically, the Landlord and Tenant Board reopened for hearings on August 1st, but in our most recent correspondence with them, which I think was about a week ago, it still doesn't sound like things are actually being rescheduled. So the latest email that I received, which was 6 weeks after they had reopened, it was about a hearing that I'd originally had scheduled for mid-April. And that email simply said, direction regarding scheduling remains in the works. So unless something drastic changes, please be prepared for extremely long wait times. Another thing to expect is accommodations. So according to their website, the Landlord and Tenant Board is using Microsoft Teams wherever possible. So I know we've all started to get some experience with these different video conferencing apps. There's Zoom, there's Google Meets, there's Microsoft Teams, there's WebEx. So the one of choice for the Landlord and Tenant Board is Microsoft Teams for when they're holding hearings. That, or they'll be using the telephone. So one thing that they've done is that notices of hearings now have space on them for accommodation requests. And those accommodation requests can include requests to change the hearing format. And I expect that this will also slow down the process. So it's necessary. I mean, if a tenant is unable to access a phone or a computer safely, and that's a reality for many tenants, they can't be denied participation in the hearing, but it means that they'll have to request an accommodation outside of a telephone or a computer. First point, I don't really know what solution there would be. I don't know if they'd be holding in-person hearings should somebody request that accommodation. And secondly, requesting accommodations is another way of sending paperwork through the system, and that's going to slow things down. So accommodations, unfortunately, are probably going to contribute to the extreme delays, even though they're definitely necessary, but that's something to be cognizant of. The next piece is limitation periods. So this is going to get a little bit technical, and I'm going to try and slow it down a little bit. I know I talk really fast. And if anybody has any questions about it afterwards, I'll be happy to explain it again. So certain types of applications at the Landlord and Tenant Board have limitation periods that attach to how long a landlord or a tenant has to file an application after giving a notice. So a really common one is after you file an N4, I believe, you have 30 days before you can, or within 30 days, you have to file an application for an eviction. And another example is if you receive an order evicting a tenant, the tenant then has 30 days to file a request with the Landlord and Tenant Board for that order to be reviewed. So those 30-day periods are examples of limitation periods. During the pandemic, those limitation periods were frozen starting on March 16th, and then they were unfrozen starting on September 14th. So what that means is that the time between March 16th and September 14th does not count towards limitation periods. So for example, if you received an order evicting a tenant on March 12th, the tenant would normally have 30 days to request a review of that order. They would usually have until April 12th. But because the freeze started on March 16th, which was 4 days after you got that hypothetical order, the tenant can now tack those extra 26 days, so the time up to when the normal limitation period would have ended, onto the end of the period after the freeze, after September 14th. So that tenant would now have until October 10th to file a request for review. Now, I don't know how many people this limitation period is really going to affect. I also don't know how many people will take advantage of the fact that they were frozen. And I don't know how sternly the Landlord and Tenant Board will be following limitation periods. I know it's a flexible body. They might be a little bit bendy on when limitation periods begin and end, especially because of the complications with the freeze. But that's just something to be aware of. So limitation periods are tricky. And if you think an order or an application that you submitted might be affected by this freeze, we highly recommend that you either speak with a lawyer or contact the Landlord and Tenant Board to confirm kind of what your status is looking like. All right, and then as a last note, the Landlord and Tenant Board increased its application fees during the pandemic. So they were initially set to increase, I believe, on April 1st to the end of March. They pushed that date back, but all of the, or at least most of the application fees at the LTB were increased by 6% as of July 1st. So if you filed an application since before the lockdown started, make sure you double check what fees you have coming for you before you submit your payment forms. It's just another way that things can get slowed down if you submit the wrong amount of payment. And I know some of us get used to using the same numbers over and over again. So make sure that you're double checking payment fees before you submit an application. So that's what it's kind of looking like at the LTB. And as I said, it's not necessarily a positive view. So what are some tips and tricks that we can have to help minimize your losses when you're dealing with the Landlord and Tenant Board? All right, now this is intimidating, but step one, I would say, would be to aim for perfection. So small errors equal big delays at the Landlord and Tenant Board, and you do not want your application to get skipped on based on a technicality. As some examples, I've seen files thrown out at the hearing level. So people have gone through mediation, they've gone all the way up to a first hearing, and then a tenant has gone and spoken to tenant duty counsel, and there's a postal code incorrect in a notice, or there's a unit number not included somewhere. And that hearing gets thrown out and the entire process has to start again. So I highly recommend to everybody, be as careful and as cautious as you can. Aim for protection or perfection. Do not let your application get thrown to the side just because of a tiny error like this. Another way to minimize your losses is to e-file your application or email where possible. So for my co-op people, and I think I saw a few rolling in on the participants list, you can email the co-op applications in, but for regular landlords and housing providers, you have to e-file in a lot of cases. Now, it used to be that you could go to a Landlord and Tenant Board location and drop off a paper copy. That's no longer available. As far as I know, the Landlord and Tenant Board physical offices are still closed. So you can either e-file or take your chances faxing an application in or mailing one in or sending it by courier. So e-filing is a clunky system. I've done it a couple of times and I did not prefer it. But that said, it's definitely better than mailing things in. It's definitely faster. So one little trick that I used was I put fake information into the e-file system and just kind of ran through all of the steps before I had any applications that I had to do. And that way you can kind of get an idea about what sort of information they're going to ask for, what kind of stumbling blocks are you going to come across. So that's a really good place to start when you're thinking that you might have an application to submit, and helps you get all of your ducks in a row before things get a little bit busier. Another tip that we have as a firm is Pester. The squeaky wheel gets the grease, and that is true in many types of law, and Landlord and Tenant Board is no exception. If you filed something with the Landlord and Tenant Board during the lockdown, follow up with them and ensure they haven't forgotten about you. One trick you can do is you can go into the Landlord and Tenant Board website, and there is an email address assigned based on the first 3 letters of your file number. So go into the Landlord and Tenant Board website, find that email address, and send them an email just saying like, hey, any updates? I don't know if these necessarily produce results all the time, but it ensures that your name isn't at the bottom of a list, and it means that someone's going to check in and see if you've been scheduled or not. If nothing else, sometimes you can get an idea about what month of applications they're currently processing. So if you're worried that you've been forgotten about, definitely don't be afraid to pester and send some emails and get a little bit of information. Agreements. So this is a bit more of a personal choice based on what kind of situations you're dealing with tenants. But ultimately, a lot of cases you're dealing with bigger issues that can't be solved by an agreement, or you're dealing with people that don't want to agree with anything that their housing provider or cooperative board says. But if possible, try and get tenants that you are considering evicting to sign on to an agreement. Encourage them to get, like for a performance agreement, for example, if there's a type of behavior that they are exhibiting that may or may not be grounds for an eviction, try and get them to sign a performance agreement that says that they'll stop doing that thing. So for example, if they keep, a common one that comes up is they keep filming people at their co-op complex or at their housing complex or on the co-op property or on the landlord property. A lot of people have cell phones now, and when they feel like they're being harassed or attacked, they'll film people on their phones. And so you can get people to sign an agreement saying that they'll stop doing that unless they feel like they're in absolute danger. These agreements may or may not be enforceable depending on what stage of processes you're at, but they can definitely be a helpful tool when you eventually make it to the Landlord and Tenant Board. And they can make places more livable in the meantime for smaller issues. If they can control some behavior while you're trying to build a body of evidence, And that's always a good thing. It makes things more livable for your other tenants and members. And it also can build evidence when you go to the Landlord and Tenant Board showing that you weren't initially trying to get an eviction. You took steps in the interim to try and mitigate for problems happening at your housing complex without immediately thinking that someone should be unhoused. Another type of agreement, I mentioned this earlier when talking about Bill 184, is payment agreements. This is a new option, but people should be taking advantage of it if they can. So this new provision is already in force, and it can be a really useful mechanism for managing arrears outside of the Landlord and Tenant Board. You can come up with a payment agreement, submit it to the tenant. If the tenant signs on to it, and you guys are able to recover some losses without having to go to the Landlord and Tenant Board, that's excellent. Things to keep in mind when you're looking at payment agreements. It still needs to be reviewed by the Landlord and Tenant Board before it can be enforced. So the process is you draft it up and then you send it to the Landlord and Tenant Board, and they give you the okay about whether or not it'll be enforceable. So to prevent delays, once again, back to point number one, you want to aim for perfection. You want to do an excellent job when drafting these agreements. And that's why I have that second point beneath where it says agreements, which is encourage your tenants or your members to access legal clinics or get tenant duty counsel. This might sound like a contentious solution or suggestion from a law firm that represents a lot of housing providers, but dealing with a lawyer on both sides of an issue can be really helpful. It can ensure that any agreements that you draft up are fair. It can make sure that they're enforceable. It can make sure that if you send them to the Landlord and Tenant Board, they're not going to send them right back to you. If your tenant has legal representation, it just means that everyone's rights are going to be covered, and things typically run a lot smoother, and there's a lot less errors that cause delays. So if you're thinking about entering an agreement, tell your tenant or your member to access their local legal clinic and see if they can get any help. A last kind of solution that can help mitigate for any concerns is community mediation, or outside mediation for non-legal issues. Our firm does a lot of work helping housing providers identify the difference between a community problem and a legal problem. The Landlord and Tenant Board is never a good place to bring community problems. And now more than ever, because of the delays, it's important to clearly identify what the reasonable and best outcomes are for your solution. And for most issues, eviction is rarely the best or most reasonable outcome for a solution. There's usually something else that can be handled there. And there are different community mediation groups that can help arrive at that solution. So if you're dealing with one or more tenants that just can't seem to get along, but none of the behavior is particularly egregious, it's a good idea to bring in outside mediation sooner rather than later. The sooner you have somebody coming in to assist with a community problem, the sooner those problems can possibly be solved or at least tamped down to a point where everybody's living more peaceably. And then you might not have to have things escalate to the point where there is behavior that would be worthy of eviction, or you might not have to go to the Landlord and Tenant Board at all. So those are some solutions to minimize your losses at the Landlord and Tenant Board. And I am realizing now how quickly I spoke at the beginning of this. So if anybody wants me to repeat anything, please just put it in the chat, because we are on to questions and I saw a lot of them popping up. So I'm just going to go through those. So the first question that I'm seeing here is, are the post-tenancy applications available for co-ops? That's actually something that I do not know off the top of my head. My instinct would be no, but I would have to double check. I know that they're available for landlords, but I do not know if they're available for co-ops. I do know that the prepayment plans, or the payment plans and agreements that you can come up with in advance of the Landlord and Tenant Board, in advance of bringing things to the Landlord and Tenant Board, those can be done by co-ops as well. So I think I did that one. Okay. Next one I have here is, you have most of the Landlord and Tenant Board provisions been proclaimed by the government to be put in force? I have not seen any updated forms on the Landlord and Tenant Board website to allow for post-tenancy applications or any of the new processes. For post-tenancy applications, I'm not sure if they have a new form for them. I know, again, for the prepayment agreements, that is in force. So The bill, the Protecting Tenants and Strengthening Community Housing Act, is in force, and most of its provisions are in force under the Residential Tenancies Act. So I wouldn't be surprised if there were already provisions operating that you can use. Okay. Given that many tenants without technology also have little comfort with forms or weak literacy, what do you think landlords who know about tenant vulnerability should do to notify tenants that they can request an accommodation and accommodate tenants in their participation in a hearing? This is an excellent question. A little shout out to Lee Webb who asked it. That's a really great question. I think you kind of answered it a little bit on your own there, where you said tenants without technology also have little comfort with forms or weak literacy. So a lot of these problems aren't new. I think the first thing you can do is a legal clinic. That's a great place to start. They deal with tenancy issues all the time and can offer a lot of assistance. And as far as accommodating tenants in their participation in a hearing, that's a really tricky question. I think it would depend on the setup that you have available at your building. I think if you have meeting rooms that you're comfortable allowing a tenant to use to access a phone, that's a great place to start. Another possible solution could be access to a boardroom or a community computer. It would depend on the technology that you have available in your building, but if you can accommodate your tenants' need in the building that they're already in, rather than having them seek it elsewhere, like at a library or at the Landlord and Tenant Board, I think that would be a really great place to start to handle any accommodation questions, if possible. The notice of hearing informs tenants that they can request an accommodation. If you know that you're dealing with a tenant that has weak literacy or has a lot of difficulty processing information, it's always a good idea to kind of remind them that they have that option, especially if you let them know in advance. One of the worst things that could happen, I think, to slow things down would be the day before a hearing, for example, you get an accommodation request and everything gets pushed back. So the more information that everybody has, the quicker and the less delays that you'll be faced with. So I hope that answered your question. Next question is, if couriering a file and the office of the LTB is closed, where would it be sent to? That's a great question. It would depend on which office I think you're dealing with. So same with the emails that I was talking about before. The office that you are processing with is identified by the 3 first letters on your application for the Landlord and Tenant Board. And they can kind of, there's a chart that indicates where the head offices are for different areas. So I would call the LTB or check online before couriering anything, just to be sure. But I know that's what I've done in the past, is just looked up what jurisdiction am I actually in right now and send things directly to that area. If your decision is between couriering or faxing, I would recommend faxing just because it's quicker and there are no physical offices that you have to deal with. Okay, I've got a question here from an anonymous attendee, which sounds very mysterious. Member and co-op have a Landlord and Tenant Board mediated agreement for repayment that's been breached. The forms were sent to the LTB from the co-op regarding the breach, asking for enforcement of the eviction. Can the co-op still accept money from the member while waiting for the eviction to go through? Yes. If the member owes you money and is willing to pay back that money, you can accept that money pretty much consistently. Just because you're waiting for enforcement of an eviction from a breached mediated agreement doesn't mean that that's the final step in getting that enforcement. There's also the sheriff's office coming to enforce. There are further steps to go, and because of the backups, I wouldn't want to deny your cooperative the income that a member owes, especially if they're just paying off arrears or paying for their current housing charges. So no, I don't think there's any issue there. We have what we believe is an illegal sublet of a unit. Very, very common, turns out. We've tried several times to contact the original tenant, but without success, so we made an application. Do you know if this would be handled on an expedited basis? I do not know factually or for sure. I would say 100% no. I can't guarantee that that would not be handled on an expedited basis, but an illegal sublet does not count as a physical emergency or something that would be handled on an expedited basis. I think for expedited applications, we're dealing with much more violent problems. So if there's weapons, if there's property damage at an extreme extent, that's the kind of thing that would be handled on an expedited basis. I don't think that that's something that would be like a legal sublet of a unit. I don't think would be covered there. I understand it's frustrating and definitely a problem for the community, but it's not something that the Landlord and Tenant Board would likely prioritize. Questions keep rolling in, so I'm really glad that I left this much time for them. When sending a repayment agreement or performance agreement to the Landlord and Tenant Board, is there any other supplementary forms that must also be filled out to accompany the agreement? That is an excellent question. I do not know the answer. I think that's something that would be available on the Landlord and Tenant Board website. I would be surprised if they didn't have a guide about how to use it. A good rule of thumb is, especially for a repayment agreement, definitely have your ledger ready. Have that prepared before sending anything in. Especially if it's a repayment agreement, I don't think there's anything else that you need. Good rule of thumb is get the ledger going back to the last time that it was at $0 owing. And that can kind of also show if there's a pattern of not paying on time. Are community housing providers exempt from the rent increase freeze? I think that really depends on what kind of community housing you provide. So I don't want to speak out of turn here and say something that's not necessarily true. For issues dealing with rent increases, I know people that are on a geared to income basis are being dealt with separately. So it's not part of the same process. And I think I'll leave my answer at that, just because I think it's dependent on what municipality you're in and what kind of housing you provide. So if it's all rent geared to income or if it's mixed. Yeah, so I would say if it's rent geared to income, that's being handled separately. Do you have any examples or know where to find a payment plan agreement that can be used at the LTB or a performance agreement? The Landlord and Tenant Board has a payment plan agreement form that they used to use, or probably still do use, that incorporated, that didn't have the eviction option. So the difference between what the Landlord and Tenant Board currently or had recently and what they have now is the new version of a payment plan agreement now includes the clause that allows for an eviction, whereas the previous ones did not. If you want to find a good example of a payment plan agreement, you can use their old payment plan form, and then you can look at the section of the Residential Tenancies Act that would allow for an eviction based on a breach of that agreement, or you can ask the Landlord Help Center, ask your lawyer. If you're a client of ours, we'd be happy to help you out drafting one of those, or send it to the Landlord and Tenant Board and say that that's a clause you would also like included, and they will likely come up with the correct wording for you and include that there. For a performance agreement, those totally vary depending on what the behavior issues are. So if you have any, this is a trick that I used when I was earlier on in practicing. If you have any previous orders that you've received or previous mediated agreements, a really good rule of thumb is to look at those and try and copy the language and try and copy the formatting to the best of your ability. That can be a good way to get the wording correct and make sure that the things that you're looking at are going to be enforceable. Our organization has an application in to the Landlord and Tenant Board for a breach of mediated agreement regarding tenant behavior. Can we also now use a performance agreement during the long waiting period for the hearing? Yes, you absolutely can. Performance agreements don't necessarily have to be attached to a Landlord and Tenant Board application. They can exist separately as a way to build evidence and also as a way to handle any problems that are arising that you would eventually like to include in a mediated agreement. So even if you have something ongoing I don't know if you're in the middle of an application, it might not be a good idea, but if you're trying to get something started and you know it's bogged down with delays, reaching out to a tenant and seeing if that they would be interested in a performance agreement, regardless of how enforceable that agreement would be a good solution to handle problems of behavior that are arising. Let's see. Tenants groups like Acorns are indicating that the bill, this says 104, but I think 184, is a way for landlords to evict tenants without going to the LTB. They recommend that tenants do not sign any agreements with the landlord. What is your view of this agreement with the landlord? I think Acorn makes a really good point. I definitely, especially when the bill first came out, I did a lot of reading about, first off, what it's suggesting, and secondly, what the impacts will be. And I would like to make it clear that as a person who is a tenant and who exists in the city and is aware of the massive housing crisis, I certainly don't celebrate anything about Bill 184, nor do I think that our firm in general is really pro reducing the rights available to tenants. And that's why I tried to say at the beginning that Bill 184 was touted very incorrectly as a way to protect tenants, and it simply doesn't do that. It affords more rights to landlords. Looking at the agreements, I think that's why it's important before signing an agreement to ensure that you've recommended to your tenant that they access a community legal clinic or tenant duty counsel. I know I've looked at a few other websites like Steps to Justice where they said a very similar thing to what Acorn is saying here, which is they don't recommend that tenants sign any agreements with the landlord. And I think that comes with the caveat of unless that tenant's had legal advice. So if a tenant can bring a copy of an agreement to a legal clinic and say, this is what they're offering me, a lot of the times they'll take it. I mean, that's usually what happens on a lot of arrears cases when you go to mediation after filing an arrears application. You go into the mediation room, the tenant finally has an opportunity to speak to tenant duty counsel. Duty counsel comes up with a great agreement that repays things on a schedule that the tenant can meet, and then you move on. So if it's available to landlords and tenants to follow that same procedure without using a mediator, I think that's ultimately a positive. I think the big concern that a lot of groups have are when you're dealing with private landlords or for-profit landlords who will use this to take advantage of tenants in a lot of cases. And that's why I do think that ultimately Bill 184 is not a positive step. But like I said, I'm trying to find some positive outcomes. It was a difficult presentation to put together that had any good news for anybody. And I think these agreements, if they're used properly and if people have legal advice, that is something that can come out of it that can hopefully handle concerns that aren't wrapped up in delays. That was a very long-winded answer, but it also gave me an opportunity to express how I feel about Bill 184. So I'm happy I got to answer that question. This is from Vanessa. It says, how do you follow up to make sure the LTB has received a file you faxed in at the beginning of September? Did try emailing, but they responded that they couldn't tell me because they don't work in the same office as the fax machine. Wow, that's a classic. That's a really great question. There's a phone number that you can call that goes to the main office, or try calling your local office and get them to give you the phone number for the office that has the fax machine. Yeah, there is no shame in asking for confirmation. I think beginning of September, a faxed form might not have made it to the designated branch of the Landlord and Tenant Board that's going to be handling it. If no one can tell you, I'd follow up again in a couple of weeks and say like, okay, has anything come in yet? And try and track it down that way. That is a very COVID and Landlord Tenant Board problem to have come across, and I'm sorry that happened. But I think that would be the best way to go. I do know they haven't been having the same kind of problems with their fax machines since August. So you're probably in the clear with early September, but yeah, I mean, chase it down and see what you can do. Let's see, what else do I have here? With co-ops, do we need to wait until after the appeals times in our bylaw before we serve the end forms? Yes. If your bylaws allow for an appeal, you have to wait until after the appeal to serve any Landlord and Tenant Board notices. This one looks like it's going to be a little bit more detailed. So if the central air conditioning is being provided under the tenancy agreement, can the tenant legally purchase a portable air conditioning unit and run it? The other members of the household are okay with the setting at 76 degrees. Are there sufficient grounds to increase his rent above the predetermined amount for each year? You know what, that one I'm going to say is a little bit too specific for something that I can answer here. It would be a little too close to legal advice rather than information without looking at an occupancy agreement or a tenancy agreement and having a bit more info. I'm afraid I can't answer that, but I think there's something worth looking into there, and start by looking at your tenancy agreement and see what it says, and go from there, I would say. Okay. We've only got 2 questions left, which is excellent. With the changes from Bill 184, if we have the repayment agreement, do we need to have the L1 to be able to get an eviction enforced from the breach, or will we only be allowed to reopen for a hearing? I don't know if I totally understand the question, so let me try and answer it in a different way. If we have the repayment agreement, if you set up a repayment agreement, there is a clause that allows you to apply directly to the Landlord and Tenant Board without having to issue notices. So that's kind of what the repayment agreement is going to be doing. So you would still need to have an L1 that would kickstart the application process, but you wouldn't have to issue notices previously, and it would get rid of the notice waiting time and the notice voiding period. So that's kind of the benefit of that. And the last one is a good one. Do you know what the estimated wait time for a hearing is right now? That is an excellent and very dark question for me to end on. I will say that I had a hearing scheduled. That was a basic arrears hearing for April 17th, and I have not received a notice of hearing. So we're looking at, and I hope they fix it, but we're looking at delays of up to about 6 months, I would say. And then, yeah, that's unfortunate. And that's, again, why I wish that I had good news, but that's kind of the delays that we're looking at right now. So if there's anything you can do to mitigate for those, I would recommend it. And I have someone who didn't understand the answer about the payment agreement and the L1. So let me see if I can take it from the beginning of the process. If you have a client, or if you have a tenant that is in arrears, you can ask that tenant to enter into a repayment agreement with you. And if they breach that agreement, you can apply to Landlord and Tenant Board for eviction. So that would be with an L1. So I believe that you start with the payment agreement and then go to the L1. That said, this is a new procedure and one that I'm not intimately familiar with, and one that I don't know if there's been a lot of work on. So I would say double check with a lawyer or with the Landlord and Tenant Board before you proceed with that kind of application. And in the interest of not giving anybody wrong information, I think I'm going to leave that there, just because it's not something that I've personally done yet, or that I think our firm has worked with yet. It's a brand new procedure, but that is what you're looking at with that. So it's just meant to get some steps and some time out of the way. And also it can make you understand why tenants are so worried about it. Do you need to submit the draft payment agreement to the Landlord and Tenant Board first? Yes, yes you do. No agreements are enforceable unless the Landlord and Tenant Board has seen it. And with that, I believe that we have handled all of our questions, which is excellent. There were a lot of them, and I'm really glad that I left a pile of time at the end there. Just as a final point, we still have our other webinars going on. You can check them all out online on our website. And if you want to join us again next week with Sophia Lakhani to talk about returning to work, tips and considerations for employers, I would highly recommend that you do so.
Hey, Carly, it's Fraser here. Just jumping in. If you want to open up the chat, there's actually quite a few other things in there as well. Yeah, sorry.
No worries. Okay. That is good to know. Thanks, Fraser, for bringing those to my attention. Okay. I've got a question about who would I recommend for mediation in Sudbury. You know what? I do not know. I don't know the area very well at all. A good place to start if you're a cooperative is your local cooperative housing federation. They often have some really good solutions. Or the alternative dispute resolution organization for Ontario. They've got a list of qualified mediators, and that could be a good place to start. Lee Webb very helpfully pointing out the post-tenancy application sections aren't enforced yet. So that's really good to know. I knew that the payment agreements were. And then a lot of this is a little bit of frantic chatting happening here. Do we need to amend our leases to include Bill 184? Not that I'm aware of. I believe most leases are still the standard provincial lease. I don't think there was any requirement that you need to amend anything. And the text of 206 suggesting that you need to serve notice first before submitting a repayment agreement is probably correct. I don't have it in front of me, unfortunately. I wish that I had that open or had copied it onto the screen. I think that would have been really helpful. But thank you, Lee, for checking that out. Ultimately, it is supposed to be a tool that you use to open a conversation with a tenant that can ultimately be enforceable. And that's how kind of the takeaway that I would want people to have today. And I'm sorry that I didn't do a little bit more research into the nitty-gritty of how it operates. Is there a charge to submit the payment agreement to the LTB? Probably. I don't know what it is, but I know that they've just updated all of their payment information, so that would be available online. And it might also vary depending on whether or not you're a housing provider that's a landlord or if you're a cooperative. So definitely keep an eye out for those numbers. I think that's everything in terms of questions, answers, and the chat. From what I can tell, I'll give it another second to see if anything else pops through here. But excellent. All right, it looks like it is all quiet on the Western Front. I want to thank everybody so much for joining me today, and also for making that more like a question and answer discussion than anything else. I think that was really valuable, and it almost made me feel like I was talking to a real group of people. So that was great. Thank you.